I don't wanna go there. We should never go there. Why you wanna go there? I guess I gotta go there. You're hearing rumors about me and you can't stomach the thought. So please, babe, so please don't judge me. I won't judge you, 'cause it can get ugly before it gets beautiful.
The recording has started.
04518.
All right. So, Brother Cannon Bey, are you going to?
No, I'm gonna let you read it this time.
All right. So, excerpts from the Citizen and Expatriation book on their requirements for naturalization on who may be naturalized. So the earliest statutes provided for the naturalization of free white persons, and this was substantially the law until the adoption of the 14th Amendment and the passage of legislation connected with it, when it was by express terms made to include the Negroes, period. A number of questions have arisen, however, as to the meaning of the statute, and under the rights of citizenship of individuals, the following races have been determined. A, Indians, early status. Our earliest naturalization law provided that an alien to be naturalized must be a free white person, and this was substantially the requirement until after the Civil War. The 14th Amendment did not, in turn, include Indians, and the Act of 1866 expressly excluded them when not taxed. Thus, by early statutes, Indians may not become citizens. A recent decision in Alaska in regard Burden 1901 Alaska 111 confirmed this by deciding what is indeed obvious, that an Indian is not a free white person or an alien of African nativity or African descent. And that, therefore, unless there was some special legislation on the matter, an Indian could not be naturalized as a citizen of the United States, the Indian in this case being a native of British Columbia who had emigrated into the United States. Citizenship has, however, in many cases been conferred on Indians by treaty entered into with the tribe itself or by a foreign government, e.g. Treaty of Guadalupe Hidalgo. I just want to stop here and say the difference between emigrated and immigrated is one who's been taken from the same land and came back to that same land.
Oh.
Immigration is from a totally different country. All right, with the I-M.
Islam.
So,
No, I'm just agreeing with you.
such treaties, see Part 1, Chapter 1, Section 1, and moreover, as there indicated, Congress has at different times passed statutes which provide that upon an individual's Indian forsaking his tribal relationships, habits, and customs, and adopting civilized methods of life, he shall be considered a citizen. See, in addition to references given above, Act of May 1890, blah, 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 and then the fact is Congress exercises complete control over Indians and Indian affairs, and so may legislate in accordance with or opposition to the generally accepted laws on the matter of citizenship. B, Africans. No question can be raised under the early laws as to the right of foreign-born Africans to become citizens. The Act of 1790 provided that to be naturalized, the alien must be a free white person. The repealing Act of 1795 had the same provision as did the Acts of 1802, 04, 24, and 28. The Act of 1870 extended naturalization to aliens of African nativity and to persons of African descent. Section 2169 revised statutes provide the provisions of this title shall apply to aliens being free white persons and to aliens of African nativity and to persons of African descent. This was not repealed by designation in the recent statute of 1906, and inasmuch as it is not inconsistent with the general provisions of that statute, it would seem that the general repealing clause as to matters inconsistent would not affect it. Therefore, by statute, Negroes may today be naturalized. Moreover, the 14th Amendment declares Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Thus, by legislation and constitutional amendment, the African stands, with reference to naturalization, on the same footing as aliens being free white persons. All of these exhibits basically came later. I don't think it's worth it to go in here, but to notice that they have, throughout the years, passed additional legislation on the same thing, but they have repealed it. Here, this one is repealed, this one is repealed, and they kind of slowly started to take out the free white persons. All white persons, aliens, if free and of the age of 21 years. That's why Cannon Bey, I saw everything you were doing was free white and 21. And then
Islam, point of interest.
Islam.
Yeah, this is Charles Hay. So is it my understanding that you cannot be naturalized unless you're a free white person, and Negroes are free white persons up until a certain point?
Mm-hmm. Yes, that's what I'm getting from it. So now, and they took away Negro a long time ago, right? They used to have it on the birth certificate. So let me see. So this was that revised statutes of the United States 1878 naturalization, where, let me just go down a little bit. All of these provisions of this title shall apply to aliens, being free white persons, and to aliens of African nativity, and to persons of African descent. So all of these pertain to us. All of these revised statutes of the United States, talking about an alien being admitted to become a citizen of the United States in the following manner. So they've got all of these, the first, the second way, the third way, the fourth, fifth, and sixth. And then telling you specifically that it's pertaining to us. So this probably warrants reading, but this is where I think they really got us. So it says the children of persons who have been duly naturalized under any law of the United States, or who previous to the passing of any law on that subject by the government of the United States may have become citizens of any one of the states under the laws thereof, being under the age of 21 years at the time of the naturalization of their parents, shall, if dwelling in the United States, be considered as citizens thereof. And the children of persons who now are or have been citizens of the United States shall, through born out of the limits and jurisdiction of the United States, be considered as citizens thereof. But no person heretofore prescribed by any state, or who has been legally convicted of having joined the army of Great Britain during the Revolutionary War, shall be admitted to become a citizen without the consent of the legislature of the state in which the person was prescribed. But this, to me, explains how they just kind of swept us into the realm of, okay, even though you were, granted, previously born out of the limits of the jurisdiction of the United States, to me is that 10 square miles being foreign. Otherwise, how could they have jurisdiction over you? And all the rest of this reads like you have to be here 5 years, 3 years, whatever. So we were always here. So we just got swept right into all of this.
So, Sister Bologna, could you just scroll up to the last section of the highlighted text.
This red here?
Yeah, the last section of it. Yeah, right there. Such person was... Could you make that correction on that term? Such person was...
Or should be subscribed is what they have. Right, that's what you're saying?
Yeah. And, so I have a question for Cannon Bey. Is he listening?
Yes, I am.
Cannon Bey?
Yeah.
Yeah,
Islam,
I think the
Islam, I'm
information that
here.
you just bolded, Sister Colonna, the word prescribed in the sentence before it is misspelled.
Got it, I see. I did the wrong thing.
What's your question, Charles Bay?
I can take that out.
Excuse me. Cannon Bey, there are a group of Moors in Baltimore. It's called Moorish American National Republic, the Divine and National Movement of North America, that are conducting a ceremony for Asiatics and telling them that they're being naturalized through the 13th Amendment with 20 sections. And telling them after their naturalization, they're actually Moorish American. This highlighted text is indicating that naturalization makes them a citizen of the U.S.
Thank you.
So, are they just conducting like a wasteful ceremony?
What they doing is nonsense. That's what they doing. Because
Okay.
only the United States got power to naturalize us in their constitution. So how they gonna have a meeting in the temple and start naturalizing people? Where they getting that power from?
Well, they claim because they have articles of incorporation for the state of Maryland to do that, then they're responsible for that purpose.
They have articles.
Still, it's
What articles is these that they have?
they have articles of incorporation of their corporate charter from the state of Maryland that allows them to naturalize Asiatics.
And that's written in their state, in their charter that they have as an organization?
Yeah.
You saw this charter?
Yeah, I have a copy of it.
Man, you need to send that to me. Let me see that.
Okay.
I need to see that. Now, the question becomes, can a 501c3 naturalize somebody? Because that particular organization in Maryland, that particular temple in Maryland is a 501c3. Now, where, for them to be able to...
But more, my understanding is that the only governmental agency on the soil of the U.S. that can do that is the United States.
Islam.
They're the only ones that can grant citizenship, irrespective of any other corporation claiming that it has articles of incorporation to support their claims.
Well, but Islam, they not the only ones that can grant citizenship. Any state can grant citizenship, but only the United States can naturalize. It's the difference. Only the United States got power to make you a United States citizen and a citizen of the state in which you reside in. No other state can grant you U.S. citizenship. They can grant you the citizenship of the state that you reside in, but not U.S. citizenship. You follow what I'm saying?
Yeah, right. But before you can become a citizen of a state, right, you would have to first receive permission from the United States to
No.
be invited here and
No.
undergo the naturalization process, correct?
No. Incorrect. Incorrect. When the immigrants was coming here, they moved and lived in any state that they wanted to live in. And that's why you got a problem right now today, because a lot of them think that they're United States citizens and they really not. They just foreign state subjects and citizens that's living within the territories of the United States. They have never been naturalized into U.S. citizens. But since they been here for so long, and their parents and their grandparents and all them been here so long, they just assuming that they're actual United States citizens, and they not. They just only people residing in the state. You follow what I'm saying? If they have not, the United States require you to do 3 things to become a United States citizen. One is you got to give them 2 years prior notice that you want to be a United States citizen. Islam, can you hear me?
Yeah, now.
Okay. The United States require for you to give them 2 years prior notice that you want to be a United States citizen. Then you got to go before a district court judge. And then you have to take an oath of allegiance denouncing all foreign princes, subjects, and sovereignties. So you have to, those are the 3 things. Until you do that, you're not no United States citizen. Islam?
Yeah, so you're saying that a foreigner can come to the U.S. soil without getting consent from the federal government to reside in any of their 50 states and live here.
Huh?
Are you saying that a foreigner can come to the United States and without invitation from the federal government and reside in one of their 50 states and live here?
Yes. What you think was happening when they was immigrating here? That's exactly what happened. A lot of the people that came after the establishment of the original 13 colonies was just immigrants coming here, getting off the boat and going to live wherever they wanted to go live at. Did you see the movie King of New York? The people was coming, getting off the boats, and they was just going to stay wherever they wanted to stay.
Well, that may have been a common practice then, but it's not a common practice now.
But what you got to understand is, listen, but what you got to understand is that common practice then, a lot of the descendants of those people are still living here. And they don't know that they not really United States citizens. Because they've been residing and living here since that time. Do you get it? This is why it's going to be a civil war over here. Because these people are still serfs. They still subjects of the Queen of England. And the time that the colonization is ending, they got to go back into serfdom. And they're not trying to go. Islam?
Yeah, Islam. I work with a gentleman from Honduras, and he wasn't able to come to America unless he was invited, and he underwent whatever their procedures are.
Right, but
you literally cannot work here.
But you
cannot
still
work here without having the consent of the U.S. government.
But you still talking about now. What about back then? Before the Naturalization Act and these laws was put in place. You talking about the early 1700s. They was coming here moving and staying anywhere they wanted to. It was a mass migration to America. The Queen sent these serfs over here to come to America to work the debt off that their families owed in England.
Well, the basis of our exchange is really my question about the Moors in Baltimore. Do they have the capacity to do what they're doing?
Definitely not.
And I would say no.
Definitely not. Exactly. They don't have power to do that. Only the United States government, and this is what you gotta realize. Ain't no organization gonna have power to grant citizenship to anybody. You know that already. Only the state can confer nationality or citizenship. Okay? And organization.
I just wanted to know that I was actually interpreting the law correctly and not missing something that the Moors are doing in Baltimore, because whatever they're doing is just filled with errors.
Islam.
The 120 was supposed to be the So,
Where do we go from here, Cannon Bey? John, they dropped it off.
the 120 was.
Right.
Yeah, I may have dropped off the screen share, but I'm still on mine. Cool.
Okay, yeah.
And I muted my side because there's people in here talking and I don't want to mess up the recording.
That hasn't even got done yet.
But what are we doing now?
So.
Go to the next. Go. Can you bring up the nationality and expatriation book?
So the amendment, you haven't done the amendment yet.
There it is. Which part you want?
Go to the first highlighted sections that we got highlighted.
Oh, well,
Okay.
that could be anywhere.
Go to the part where it's speaking on Christians and Muslims.
I'm listening to it. I don't understand what you're saying. I didn't give you 120 to do the amendment. What did you keep talking about?
I'm gonna have to do a search. I don't remember where that
I'm
was.
listening to you. I gave you the 120 to do the amendment. What are you talking about? We talking about the amendment. I'm not even talking about the extension thing. You said, okay, I'm gonna do it.
That's in that extraterritoriality portion.
We talking about just the amendment, but I gave you 120, and I was supposed to give you 2 papers.
We already know that part. That's not a good thing. Maybe I'll bring up Muslims.
Islam Cannon Bey, I'm going to email you that document right now. Okay?
Discussing money, the son already had paid you. You keep saying money.
Islam.
Why you keep saying money? We did that.
Ty.
Sister Columbia, do you want to be included on that as well? Or?
Oh, yes, please.
Okay.
So this one.
We not talking about it. The amendment's supposed to be put together. You was gonna do it that day. Okay, so what the 120?
Kelowna, you read it.
What was the 120 for? You still.
Although
What was the
it is
120?
not within the scope of the present memorandum to study every aspect of the conceptions of nationality underlying the Muslim Sharia law, its influence can nonetheless be traced in the drafting of the present Ottoman law of nationality. The extraterritorial privileges known under the general name of capitulation or treaty rights and enjoyed by the great majority of non-Ottoman residents of the Ottoman Empire are well known. At a time when the non-Muslim subjects of the empire were not on an equal footing with the Mohammedan fellow subjects, it was natural for the former to look with envy at the superior legal position enjoyed by foreign subjects in Turkey.
Whoa, stop right there. Are they making a distinction between non-Muslims and Mohammedans? Okay, alright.
No?
Absolutely.
Alright, thank you. Forgive me. Sorry for interrupting.
Okay, no problem. In a country where theology and law, as well as religion and nationality, were often confused, a Christian Ottoman subject of the Sublime Porte, which I believe is the Turkish government Porte, would endeavor to find the means to enjoy the same rights and immunities as were enjoyed by the Christian subjects of some Western power, for in his own mind, the question of subjection seemed identical with that of religion. The stronger Western powers protected not only their own subjects in Turkey, but those as well as of other and smaller countries. Gradually, the representatives of foreign countries protected in Turkey certain Ottoman subjects as well. This protection, which culminated in nationalization or naturalization, was not suddenly imposed on the Sublime Porte in its entirety. The capitulation, or treaty rights, were there, or else in course of formation, and the interpretations and extensions to which they gave rise were ready for application, backed and strengthened by precedent. In conformity with the capitulations of 1569, the interpreters of the French ambassadors were protected by being exempted from all subsidies and imports. By the year 1740, this protection was practically extended not only to all employees of all the diplomatic missions, but even to those of the consulate. Now that's a distinction between mission and diplomatic mission and consulate. For certain diplomatic and consular officers, this word employees was taken in so broad a sense that it included not only genuine employees and servants of every kind, but even friends who might be in need of protection. In addition to real diplomatic and consular officers, there was thus added a class of wealthy non-Muslim subjects of the Sultan, to whom were granted the titles of Venetian, French, Dutch, or English consuls, and who were protected by their respective diplomatic missions, and in turn protected their own employees with their families.
Wow.
To these were again added certain merchants called baratlis, as well as agents and brokers dealing with or for foreigners. So that in the 18th century, there was a large and increasing number of native subjects of the Porte who, without obtaining foreign nationality, were yet partakers of the general extraterritorial privileges enjoyed by foreigners. This was followed in the 19th century by wholesale naturalization granted by some representatives of certain powers, not only to protégés, but even to non-Muslim subjects of the Porte who had never been outside the frontiers of the empire. Now I want to just stop here for a moment to go to the word protégé, because they say, what page is this? They call Morocco a protégé. Let me go back. Very forward.
Yeah, the question is, when they do that, are they talking about
Here it is.
the Kingdom of Morocco?
So this is under subject Exhibit A, countries in which the United States exercises extraterritorial jurisdiction. This is for the treaty provisions regulating extraterritoriality in the countries marked with an asterisk. See ISRA Exhibit C. So this is not marked with an asterisk, Morocco. It says the protégé system in Morocco was regulated by a convention signed by several powers at Madrid in 1880. That's that convention that we read. And then in 1904, Great Britain recognized the predominating influence of France in Morocco. Protégé system in Morocco was regulated by a convention. The protégé system. I would really like to know what they're talking about there.
So the protege in this case would be France, who may have been privy to more of the diplomatic processes, and were then, because they colonized Morocco, teaching Moroccans the diplomatic processes, in my opinion.
Yeah, because they did have that treaty in 1863 with France. Yeah.
Yeah, but I think it was vice versa. I think they was teaching the French.
That's what he was saying. That
Oh, okay.
France was the protege. Correct,
Exactly.
Jose?
Yeah.
All right. where we were, but it seems like proteges is being explained more. Formerly, especially in Turkey, the various powers possessing extraterritoriality were accustomed to extend their protection to a large and somewhat indefinite number of so-called proteges, who placed themselves under the protection of their consulates by registering therein and submitting to the consular jurisdiction. The legal opinion of Edward Pierce. This system naturally excited objection on the part of the native government and has been in recent times steadily discouraged on the part of all the powers, especially by the United States and Great Britain. You see the convention limiting the rights of protection in Morocco concluded between all the great powers in Morocco in 1880.
When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note. This note was a promise that all men, yes, black men as well as white men, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness. We refuse to believe that the Bank of Justice is bankrupt. So we've come to cash this check, a check that will give us upon demand the riches of freedom and the security of justice.